Good evening, friends. And as we had promised on an earlier occasion that we will be taking 3 sessions on the Indian Succession Act, 2 parts were already there by Honorable Mr. Justice Rajive Bhalla, a former judge of Punjab and Haryana High Court. And the third aspect in respect of probate and letters of administration. This is an issue which normally we all find, and especially letter of administration of late, we find that the estate officers, etc., do call upon that at least bring the letter of administration. And a common man does ask the lawyer known to him, maybe not even as a professional advice, as a friend, sometimes they do ask what is the way forward for how to go about it in the letters of administration. Therefore, in the part 3 of the Indian Succession Act on the sessions being taken by Honorable Mr. Justice Rajive Bhalla, we will be covering these aspects, and even though we would be covering the legal aspects, but we would also be covering, as we had requested, and it was also the brainchild of Justice Bhalla, that how to go about it would be an aspect to be covered in this topic. And as usual, we will be taking questions at the end of the session. And as usual, again, we say that keep on wearing the mask, get yourself vaccinated, and maintain social distancing. This was also actually an idea conceived by Justice Bhalla when we were talking about the different sessions. He said that you should also post it on the invite so that if any one even can be sensitized on each invite, that helps us to build the nation strong. Without taking much time, I will request Sir to take over things. Over to you, sir.
Thank you, Vikas. Today's session, before I begin today's session, I'd like to actually pay my respects to all judges, advocates, people of court staff, other friends and relatives who passed away in this horrible pandemic. And as we wait actually with bated breath for the third act in this tragedy that has struck the world to unfold, let's hope it's better than what's happened till today. So with these few words, I mark my respect for all those who passed away and hope all those who've been through this trauma emerge stronger and we don't lose any more friends, relatives, lawyers, judges. But I think everybody's been touched by it in some way or the other. And yes, we will always blame somebody or the other, but then to an extent, we ourselves are also responsible. So let's all get up and take responsibility and not allow this third act to play out its course. So now coming to the topic, as Vikas had said, I had promised that we'll make it into a 3-part this thing on the Indian Succession Act, but somehow the first 2 were done, but the third somehow got left out for reasons of pandemic, trying to help out to do things for people, etc. So this third in this series of the webinar, the other 2 are available on YouTube if anybody is interested. What my attempt is to move away from the academic actually, and to put even before a lay person the Indian Succession Act in its simplest form, so that you have a faint idea. You will never have a complete idea, because once you'll open one section which I'll explain to you, you will find a third one which will contradict it or will confuse you. So to make it as simple as possible, I'll just I've done succession certificate, I've done proof of will, I've done will, execution of will, all those things. So we come to probate. Now, probate is a term all of you hear, probate and letters of administration, and lots of you hear it on a daily basis, but it's something more or less, apart from the people in the legal profession, and many in the legal profession also, it's some sort of a mystical term that what is this probate and why, how, when, what, where, all those things have to be there. So it's actually in the Indian Succession Act, Chapter 9 of the Indian Succession Act, 1925, and sections 217 to 369. But in view of the limits of this webinar, I will not be taking anybody through these sections, but I'll take you briefly through, there are two types of succession. I think you're all aware of that. One is testamentary succession, which is if there's a will, and the second is if there's no will, in which case either succession will go on the basis of the personal law of the parties, whether depending on we are Muslim or Hindu, Christian, and in the Christian community you have different denominations which have different types of succession. So these, you have to be very conscious of these two parts, and then I'll take you to what is the difference, what is probate and what is letters of administration. You all heard of three figures in this thing. One is called the testator, is the person who executes the will during his lifetime. And then this beneficiary in whose favor it goes. And then is the executor or the executor, as we many of us like to pronounce it. Now, the latter is the person who has the right to seek a probate. If there is a named executor of the will, he has the right to seek a probate. Now, what is a probate? Probate is nothing more than a certificate granted by the court that this will is legal and valid. Executed. I purposely left out that word. The will is legally and validly executed. It is not a declaration that the property which is part of the will was legally and validly owned by him. It's not a declaration that this property was his personal property or was his HUF or ancestral or kopasnari. All that it will declare by way of a certificate which the court will grant is that the will has been validly executed. And if you're from the legal profession, you will know that the sections under which it is executed under the 68 of the Succession Act and proved under 63 of the Evidence Act. That I've already been through, so I would not like to spend any more time on that. Now, how do you file a probate? And the first question that always arises and people ask at many forums is it compulsory to have a registered will before you file a petition for a probate? The answer is no. A will does not require registration, and therefore you can seek, and in case you're able to prove, you will be granted a probate even if the will is unregistered. We only get the will registered as a matter of caution to add a little strength to the will. So it's not that it's necessary that it is registered. Now, coming to the operation of the areas in which we have to obtain a probate. It is not compulsory to obtain a probate in about 80% of the country. The only places where it is compulsory is if the executor of the will, let me call him the testator, a proper word, resides within the presidency of Bengal as it originally stood, which we now call the Calcutta High Court jurisdiction, the Madras High Court, which was originally Georgetown, if you people will remember, Fort Georgetown, and third, the jurisdiction of Bombay. So if a person resides there and makes a will, then necessarily he has to seek a probate. If the property is situated with any of these three jurisdictions, then also he has to obtain a probate. In the rest of the country, it is optional. So the question arises, then why should I go and seek a probate if it's just optional? And I'm living in Delhi, I'm living in Chandigarh, I'm living in Jaipur, I'm living in Kanpur, I'm living in a town, so why should I seek a probate? Well, the answer is that it's a simple, easier, and at times even a cheaper method of obtaining a validity of will than instead of going to file a civil suit to seek a declaration. So most people, in jurisdictions where probate is not compulsory would also file a probate. And my advice to people is that please file a probate. Don't go to file a suit. In a suit, you may also end up paying ad valorem court fees. Whereas in a probate, you pay a much lesser fee. So this is another reason for people to file a probate and not file a suit for declaration. Then the court can also turn around and say that if there's no dispute in the will, what do I adjudicate? So you can throw your suit out also. There has to be some dispute on a will. Whereas in a probate, there need not be a dispute. I'll just take you to what is required in a probate. There need not be a dispute. You are just seeking a declaration that this is the last valid will of the testator. That's all, period. That's about. Nothing more, nothing less. You are not seeking a declaration of his title. Moment you go to civil court, you'll have to seek a declaration of his title also. And then court fees will come in, stamp duty will come in. So I think my little advice to everybody is that, and to lawyers here and to people who are not from the profession, seek a probate. It's a cheaper alternative. The only thing is we in courts and lawyers also get accused that it's a never-ending process. Yes, this dark night of litigation, which I call it a dark night of litigation, does not end. But a clever litigant and a good lawyer is always hands-on. And if the litigant associates himself with the lawyer, it's not very difficult to get your case decided quickly. Most of the time, what we notice is that lawyer leaves the client leaves the brief with the lawyer and says, okay, call me when you need me. So lawyer has lots of other work to do. So it's a two-way street. Both have to work together. So it's a quick process, provided you are totally hands-on in this. So now coming to, I've already answered why finality. There are lots of organizations, like even sometimes when you have to seek transfer of shares, they might ask you for a probate. You might sometimes, even some bank manager sitting may say, okay, please go and obtain a probate. You may have a flat, your person may have a flat which is in a society. They might want you to seek a probate of the will. And then, of course, there might be some dispute between you both, or 3 or 4 of the beneficiaries. It's a better place if the dispute is only with respect to the will and not with respect to title. Then the best place to go to is to seek a probate. Why do I say? Another reason, when you go to a civil court, you'll go to the lowest court. But when you go and file a probate, you will go straight to the district judge or to the high court. Under section 300, the jurisdiction of the district court and the high court is concurrent. You can go to either. So you, in essence, may cut out 2 or 3 steps of the litigation ladder. If you go straight to the high court has jurisdiction, the district judge has jurisdiction. So it's either way. Only thing you've got to be a little careful is that please look at the high court rules and orders. Each high court, in addition to what is written in this act, has its own rules and orders. You're all aware of that. So please look at that before you file a petition. I'm sorry, if I'm addressing lawyers, I shouldn't be saying that. That's a basic fundamental thing which I should not inform lawyers. But since there are many people who are not from the profession, so my idea is to explain to everybody, not just to lawyers. Now, coming to this, who can obtain a probate now? If you come to the opening of the act, a probate, like I already said it can only be obtained by a Hindu, a Sikh, a Jain, or a Buddhist. Muslims are not entitled to probate under this act. Christians have been excluded in 2005 or something. There's an amendment. They have a separate dispensation for them. So basically, it's left only for these communities, because Muslims have their personal law, Christians have their personal law. They are minorities. which are rightly protected by the Constitution. And they have different dispensations within their religions, which have different methods of succession. The Christian world has innumerable churches and innumerable, similarly with the Muslims. So it's not the only thing which comes in the Succession Act is, but if there is no will, the first condition is there has to be a will, registered or unregistered. Now coming to our personal laws. Now suppose a person does not execute a will, but he leaves behind properties. So what do you do then? Can you come under the Indian Succession Act? Because I'm emphasizing again and again, will. Yes, you can. That's where letters of administration comes in. Letters of administration is a certificate again granted to you just to deal with the property of the person. It doesn't give you a right. You may be a beneficiary, but eventually it gives you a right to deal with the property, to save the property, to collect the property, and then disburse it. It's something just slightly less than a probate. In a probate, if you look at the act, everything comes to vest in the executor or in the beneficiaries, who then give it to the beneficiaries. So the distinction is very palpable between the two. But at the same time, courts may sometimes, instead of granting a probate, even where there is a will, grant a letters of administration. They say there is nothing to be probated. The will is valid. So why are you seeking a declaration? So here I give you letters of administration to administer the property. It's not a question of there may be debts to be paid. There may be debts to be collected. That is where administration comes in. Probate will give you complete rights. The property will vest in you. So that is the distinction. Now, another frequently asked question is, what is the limitation for filing a probate? Suppose a person dies in 1970 and you go and file a petition in 2020 on the basis of will. Normally, we would say it's time barred and throw it out. But no, there is no limitation provided in the Limitation Act for approaching the court of competent jurisdiction to grant a probate. But at the same time, if you all remember, we have the Limitation Act where there is a residuary article 137, which says where no limitation is prescribed, it shall be 3 years. So the limitation to approach a court for grant of a letters of administration or grant of a certificate of probate. I request everybody to start using the word like this, certificate of probate. We keep saying grant probate, but the law does not say grant a probate. It says grant a certificate of probate. I mean, it's just a nice and a better way of putting it if you're a lawyer. A certificate of probate. Otherwise, it makes no difference actually. Everybody understands what's the meaning of granting a probate and what's the meaning of letters of administration. Just a better way of putting a fact across. Now, once you have this limitation, so where will this period of 3 years commence? This is the most important thing for a lawyer. A litigant comes to you, he shows you a will, and you say, oh my God, this was executed in 2005, I'm 2021. Now, how will I justify? Because original proceedings, section 5 does not apply. I hope you remember that. There's no condemnation of delay in an original proceedings, except if the act provides it. Now, this act does not provide that. So what will you do then? Then you ask him that when did the dispute arise as to the will? On which date did somebody ask you to obtain a probate? On which date did any of the other beneficiaries refuse to accept the will? On which date did an officer in the court decline, not in the court, the administrative officer declined to record a mutation or a report in your favor? that is the date limitation will commence. You all know cause of action. Cause of action to obtain a probate vis-a-vis limitation is not the date of death, or obviously can't be date of execution, because a will only comes into effect on the death of a person. It's not the date of death, it's the date when the will is called into question by somebody else. So if nobody else, you take out the will after say 15 years, and then somebody says, sorry, I'm not relying on this, this is wrong. So then you go in for a probate. Limitation will start from that. Please search for a Supreme Court judgment of the year 2008. I'll refer to it later. Somehow it's missing from my record, but that's the date. This limitation is a very important part, because people have a habit of not approaching the courts expeditiously or within time or within what they should normally be doing. And then even my own community also has a habit of sometimes delaying matters. I have to be honest about my community also. So to all lawyers, a small bit of advice: don't get disheartened if somebody comes to you. I'm not saying create the dispute within 3 years, but find the dispute within 3 years. That's a different way of saying the same thing, but a better way of saying it. Find when the dispute commenced. So you will be well within your right to obtain a probate. Otherwise, the first question the court will put to you, and you know it very well, there is Section 3 in the Limitation Act, which obliges a court to reject a claim which is rejected at the outset. It's a question of jurisdiction. Limitation is a question of jurisdiction, though it's a mixed question of fact and law. So you must, when you're writing your petition for probate, you must, if it's delayed, if it's say 3 years beyond the demise or something, so normally lots of people come on time only. I'm just trying to be more dramatic in my putting it across, that people don't come for 10 years. It's never like that. And so please add that if you're beyond 3 years, then please add a sentence that this was called into question on such and such year at such and such place. Therefore, I am within limitation of 137. Otherwise, the honorable judge will ask you a question and then you'll be explaining it. And then when the judge refuses to accept then you'll go up to the High Court and say, I didn't do this and this was not done. So please be very careful on how you draft it. Now coming to the basic fundamentals of a will. The day the person dies, the day the person passes away, the will comes into operation. Your inheritance opens on that very day. It does not remain in abeyance, whether it is under the Hindu Succession Act or whether it is under the Indian Succession Act. It comes into force immediately. The enforcement can take place later. Why I say this is because there'll be beneficiaries who will deal with the property. It's not that if there's no probate, you can't deal with the property. You can accept the rents, you can do it, but once you are in court, then you have to seek permission of the court. And those are acts also which can be rectified. There are provisions. I'm not, for want of time, I don't want to convert it into a classroom lecture, but there are provisions where you have the right, if you are the executor or if you're the beneficiary also, to deal with the properties. Now, what do you do? In fact, I think time has come now. And in fact, it's happening in many jurisdictions. I am the beneficiary of one such order where the executive authorities accepted the will because all beneficiaries filed affidavits acknowledging the signatures of the deceased, acknowledging the will, and they recorded the change of ownership in the name of the beneficiaries. So please try and insist on the executive authorities also that you have the jurisdiction to do it. It's a valid will. Either record an order that you do not accept the will, then you'll go to court. But what's happening in most jurisdictions is that almost as a matter of routine, the officer where your property is registered will tell you, sorry, I am not going to go into all this. You give me an indemnity bond, you go with an indemnity bond. Then he'll say, oh, sorry, I don't know. You've given me the number of people who are beneficiaries. I'm not too sure. How can I be sure? Now I'll put it in a newspaper. No objections have come. Doesn't make any difference. Sorry, please, I'm not giving it. I'm giving it to you. Please go to court. That's where you have to come to probate. So if you encounter some sort of such a rules, please come to court straight. And for people who are scared of coming to courts, I mean, I can assure you, we are not that bad people, whether we are lawyers or we are judges or anything. It's just that you have to be involved in your own litigation. You can't just leave your litigation and expect somebody to do everything for you. So that's the way it goes. Now, I've already told you that where is it to be filed? It has to be filed before the district judge, where the deceased was residing and made his will, or where the property is situated. And the same jurisdiction travels to the High Court also. If he is situated, if he lives within the jurisdiction of, say, the Kerala High Court, the property is also situated in Kerala, no issue. He can go to the district judge, whoever is there, and he can even go to the High Court, depending on him. At times, the High Court may also send you back and say, go to the district judge. I mean, we've got better matters to do, or we've got other things to do also. And lots of times this happens. And sometimes they entertain it. And then you have this situation where the property is situated in two jurisdictions. Say one property is in Kerala, the other is in Punjab. And maybe there may be a third jurisdiction also. And the person, say, resides in Delhi, has property in Kerala, has property in Chandigarh, and has property in Madhya Pradesh. I'm excluding the three presidency towns and presidency high courts. So in that situation, you have the right to choose, and the court has the right to say that since major part is situated there, please go there. But if the will has been executed, say, in the jurisdiction in Kerala, then normally the court will allow it. Now, why I tell you that it's better to go to the place where the major part of the property is situated is because then you'll have to carry the certificate from one jurisdiction to the other to seek transfer. The authorities in Kerala cannot transfer the title of the property in Madhya Pradesh. So it's better to have one jurisdiction and then request the court to transfer it to that, if you know that precept, how a precept goes in civil law. Otherwise, you can't file three petitions on the same will, one in Madhya Pradesh, one in Kerala, and say one in the third jurisdiction. So small advice, everything included there. Now, what are the contents of a petition for probate? This is something very important. Everybody needs to understand. Lawyers can read it from the section concerned. The section is section 276 is the section which gives you the particulars of the probate. At the end of this thing, there is a format of a probate also. And section 279 is the petition for letters of administration. So both of them are prescribed. Now, what do you exactly have to write? You have to, when your letters of administration, there's no will, so you don't have to refer to a will. You have to write the time of the testator's death. Of course, you'll write the name of the testator. You'll write his lineage. And you are annexing therewith the original copy of the will. That has to be attested because its probate is granted, a certificate of probate is granted to a will attached to it. that it is legal and valid, and to nothing else. It's not a decree, it's not an order, it's a certificate. Please be very clear on that. It's not a judgment, it's not a decree, but what is granted to you, the certificate, is preceded by a judgment of a court. That's a separate matter. So that, and then that it was duly executed. These are the witnesses. These are the assets, the properties which are subject matter of the will. The application is for probate, that the petitioner is the executor or the beneficiary. Like I told you, an executor can also file it. There are situations where you appoint an executor, and after you die, the person says, sorry, I'm not ready to do it. So then he has to renounce his obligation. There's another provision in the Act. He can renounce his obligation to get the will probated, and then the beneficiary can go. But there are situations and there are judgments where the executor did not go, and the poor beneficiary was kept on running after him that please go to court, please go to court. In such situations, the courts did allow the beneficiaries, and there are many sort of beneficiary, primary beneficiary, the major beneficiary, the minor beneficiary, to come to court. Sometimes all of them came to court, sometimes one came for the benefit of everything. So it's not as if in every case only the executor of the will come. And there are many cases known to law where executors have been known to exploit things and have been known to. So it's better if you try and associate the executor and join him also. Don't just leave it to him. These are just words of caution, probably from my experience in life or experience as a judge, as a lawyer. You must then also value the properties. Why do you need to value the properties? Because there is a particular probate fee which is less than the court fees and the stamp duty. Normally, I don't know what state governments then keep on increasing it because it's a state subject. Then the identity of the witnesses is very, very important of the will. And then if registered, the exact name, place of the registrar's office, because there'll be a stamp also. So it'll be written there, but you must write all this. And if you want to be more particular, the place where the will was executed and the place where it was registered. Sometimes the place of execution is one and the place of registration is one. So please be very careful in giving all these particulars. And since we have lots of people who live in our mufassil areas or even in our towns, so you also have a person called a scribe of a will. Nowadays, we have lawyers who are professionals in executing and in drafting of wills, but in every district, there is a scribe who is authorized to scribe documents by the district judge or by the district magistrate. He is granted authority. So the identity of the scribe will go a long way in helping you to prove your will. So after that, it has to be verified as per the CPC. We have normal verification rules. And most important of all, and please don't forget this, the application for probate must be certified by at least one witness of the will. Preferably get the certificate of both at the bottom of the will, preferably. See, because if suppose one is there and he's not available or he backs out, you have the second there also. And then in your petition, you suppose I file the petition and I have other brothers and sisters also. So I must array all of them as respondents, and depending upon your high court rules and orders, the general public too. Because a will is not a declaration, this is a declaration in rem, not in personam. It applies, the legality is an announcement to the world at large that this gentleman or this lady who has passed away has made a valid will bequeathing her properties to persons A, B, C, or organization A, B, C, whatever it may be. And therefore, we grant a certificate and certify its legality and validity. Now, coming back to a point where I started, the distinction is the will is legal and valid. The bequest may not be. Take an example. A person is a member of the property in my hands is ancestral. So my grandchild and grandchild will also be will have a shareholding by birth if we are all Hindus. Now what happens if I bequeath the entire property? Can they come and say that no, you could only have sold 1/3 or you could only have made a will for 1/3 of your share? Yes, they can, but it will not come in the probate. My will will be held to be valid. For that, he will seek a declaration. This is a little dichotomy in the law. Unfortunately, we got this law from the British when times were easy. So I am of the opinion that this probate jurisdiction should also have a jurisdiction within it to determine the title of the parties also, maybe by a separate declaration. Because now in this situation, I get a declaration that the will is valid. My father has made a valid will. And then my brother comes along one day and files a suit seeking a declaration that the father's bequest is not valid. The will is valid, but he did not have a right to. So why can't we do it in one? It's just like I have another favorite topic which I speak everywhere, that all the lawyers here would understand that we have something called the CPC, where most of the CPC is taken up by one order called Order 21, which is the largest order, which is more or less like an act itself. And it's not even a rule or something. So once you got your decree in your favor, that's the time the fun and game starts. And that's the time you are given a rigmarole running around. So why can't we have a rule in the CPC also? Sorry, I'm digressing from the topic a little. Why can't we have a rule where the person against whom a decree is passed asked to come to court within 30 days or 90 days and show satisfaction of the decree? We have this whole huge Order 21 running into how much? I think 123 rules just to execute a decree. And it's a lawyer's paradise because there are so many, it's a minefield. So if somebody has the ears of the government, I don't, you can please tell them that time to think of this, getting rid of all this matter. Probate, why can't you have declaration at the same time? I don't understand. Why not? Why we divided these jurisdictions? So we should have a probate, and this is an idea I'm putting in all your minds. If you people can take it forward at some fora, somewhere, there'll be somebody who may know people in power somewhere. They can start this. There's so many professors, lecturers, lawyers, everybody. We must start making the law more responsive to the needs of today's times and not live in the CPCs and this is 1925 Succession Act. And procedurally, it has not budged an inch since 1925. I don't criticize the system, but then nobody's given thought to it. So somebody has to give thought to all this. Now, similarly, coming to the declaration for letters of administration, same thing, times and place of deceased death, the family or other relatives of deceased and their respective residences, the right in which the petitioner claims, the amount of assets which are likely to come to the petitioners, and when the application is to the district judge, then the deceased at the time of death has a fixed place of abode. That is also important, like I was telling you, if he's residing there, within the jurisdiction of so and so, etc. And then, of course, you have this entire thing goes around the procedure. But when you'll go to court, every judge in a probate will ask you to get the petition published in the newspaper. And now in today's times, probably you'll have to go online. I don't know, most papers are going paperless, and It's very difficult. And that itself is quite expensive. Getting a publication in a newspaper is quite expensive, particularly if you are asked to put it in a national newspaper. It'll cost you nothing less than 50,000 rupees. So I think we need to devise some other method of putting it in the public domain. If we want to make litigation, what we keep saying as judges and lawyers and even as politicians, okay, we will make justice cheap, it will come to your doorstep, it will all this. But sorry, that's not the way it is. If a poor person comes, I mean, it's just wastage of money. Public, for 50,000 rupees, you put it in the newspaper. For a person, it's just wastage of money. So this, another thing I'd like, this is something all of you can think of. Alternatives, I can't find an alternative, but we have younger lawyers who see so many things every day and they are finding solutions to everything. So they can find a solution to all this. And now actually the Chief Justice of India has formed a committee, the AI committee, to help in court work, artificial intelligence. But I think this is something where even normal intelligence is just needed, nothing more than that. Then coming to who can be a beneficiary, I think you're all aware of that. If it's my personal property, I can will it away to anybody. My will cannot be challenged on the ground that I have executed a will in favor of person XYZ who is not related to me. So the normal principles of will apply. You will have that same old fight going on then for that. Verification, I've told you everything. I've told you Section 300 prescribes concurrent jurisdiction of High Court, and limitation, I've also referred to it. That's about all. Basically, I just got to wrap up now. And then I've got to subject myself to any questions which any of you may have on probate. It's actually that simple, but getting this probate takes years and years. One small request to you, which I forgot to make, and this comes from my experience as a lawyer and a judge. When you'll file the original will in court, please make an application that it should be put in a sealed cover and be put into the custody of the registrar or whoever is the senior most official in the district court. Why? Because if it's tagged along with your petition, it moves from place to place, and you might not, when the time comes to prove the will, you might find that the will is already torn or in pieces, or relevant portions are missing from it. So this is a request you must make. So I think I'll now wind up. And any other questions? Yes, somebody has already put up that 2008 SEC on limitation. So please look it up from the chat box. It's there. So any questions, Mr. Chatrat? Because what questions I've got, I've answered.
Yes, sir. I will take the questions. In fact, I was hearing through the headphones.
Okay. Come back to your ears.
This is by Somil. How to divide the property after obtaining letter of administration?
See, letters of administration gives you a right to deal with the property. Normal division is going to be the normal rule of partition. If it's a property which is agriculture, then you'll have to go to the revenue officers. They will do it. And if it is not agriculture, it's urban, then you'll have to go and file a civil suit. That's what I was trying to get at. Why can't we have a single forum where you get a probate also, you get the division, the properties are also, in case there's any dispute, all disputes are decided at one shot. This is exactly what I'm trying to say. In fact, this is the example I would have given. And next question.
A case in which petition has been filed for seeking probate. And even if it is non-contested, yet it can be rejected.
Yes, it can be rejected if he is unable to prove the will that has been validly executed, if unable to prove the ingredients of due execution of a will, sound disposing mind, then that he has signed in the presence of the other witness, signed himself, etc. Those all the elements of Section 68 of the Evidence Act and to be executed as per 63. Any next question?
Whether a letter of administration can be obtained in respect of an immovable property.
Yes, it can be. It's only a right to administer the property. It does not give you a right to sell the property. A letters of administration.
Whether the beneficiary,
if you want to sell it, you'll have to go back to the court. You can divide it amongst the beneficiaries who are ready to take it. That's all.
Whether the beneficiary himself can become one of the witnesses in the registered will.
There's no prohibition, but it is not advisable because a beneficiary is not supposed to participate in the execution of a will, because the objection that will come if it is contested will validly be that he prevailed over the will of the old man or the old person or anybody else and got him to execute a will. So it's a very, very dangerous thing to become a witness. But yes, if you are depriving somebody of property, then please try and make him a witness. Then he can't get out of it.
Kindly clarify on the aspect of nominee vis-a-vis beneficiary in the light of subject today.
Nominee in the light of?
Nominee vis-a-vis beneficiary.
Nominee as in what?
Also, nominee vis-a-vis beneficiary. What is the difference between the two?
Nominee, normally you don't have a nominee in a will. In a will, it is the beneficiary. Nominee is in your bank accounts or in your shares or in those things. So beneficiary is the person to whom the amount is given in the will. And if he's a nominee, then they will contest amongst each other that I am the nominee. And in case the court gives a declaration that the property has gone to person A as per the will, then the nominee will have to cede. Next.
Can an executor file for certificate of probate if he is a party to the same suit schedule, property pending?
Yes, why not? There are many executors who are beneficiaries also.
Yeah. Is an appointment of an administrator by the testator in the will mandatory?
No, it's not mandatory.
Can there be a family arrangement amongst the issues even though one of them has a will in his favor?
A family arrangement presumes a resolving of issues arising from anything, whether it's a will or it's not. Even a will can be part of a family settlement. I think if that Kala Singh judgment of Supreme Court was regarding a will also. So there's no prohibition. Family settlement is one very strange animal in our country where there are no holds barred, anything can be done, provided it's an oral family settlement. If it's in writing, then it requires registration.
Does applying for probate make sense in Delhi where it is not mandatory?
Like I told you, that in 90% of the country it does not apply. But it makes sense to apply because otherwise you'll go to the magistrate first. You'll go to judicial magistrate first class first. Then from there, you'll go and appeal to the district judge. Then from there, you'll go to the High Court. Then you'll go to the Supreme Court. Here, you can land straight in the High Court with a probate, provided there's not too much of a dispute. But then the difficulty is if there is dispute, then you might land back again in the magistrate as far as declaration of title is concerned. Distinction between will and title.
This question is at 647. Distinction between section 276 and 278. Yeah. 276 uses word will and letter of administration, whereas 278 does not.
That's what I said right at the...
Maybe he's only clarifying for the audience. How can an administrator distribute the property?
You heard me. There is no need for a will in the case of a letters of administration. But in certain cases where the court feels that in the case of a will also, they may grant letters of administration instead of granting a probate, where certain debts are to be collected, etc. Please, you'll have to, the judgment is not with me, but I was a lawyer in one of these cases where instead of probate, the High Court granted us letters of administration. In essence, it doesn't make much of a difference, but the impact in law is very different.
So you could explain the difference also once we are touching upon that.
The difference between?
You're saying there's a difference between the two.
Yes, because in a probate, the entire property vests in the person to whom probate is granted. And then he is liable later on to account for the property, not only to the court, but also to all the beneficiaries. In this letters of administration, if somebody has 278 before him, it's very clear he only gets it for the purpose of collecting the properties. See this. Letters of administration shall be made by a petition distinctly written as aforesaid, stating. Now, what is it for? If you can read it, somebody can read it. Actually, we need to have a separate session on letters of administration. These two things can't be put together like this. Just by telling you the differences, it's okay. I have no issue on sitting here for the next half an hour. But actually, I've got something else lined up later in the evening. So I have to. Any other question? You can send the queries separately also. I'll answer each one of them.
Few questions from the YouTube I'm taking.
Yeah.
Letter of administration case is on witnesses examined as per will. Challenger has not predicted. This is a query.
He's got it mixed up. No?
Whether will be valid and effective when testator is convicted in a criminal case.
Testator is convicted in a criminal case. I'm so. The testator. How does that? I mean, I'm sorry. I'd like to ask the gentleman the question if he's hearing me. How is that relevant? A person can make a will even before he's being hanged. Just because you may lose your right of inheritance in case of if you killed your father. That's the only situation where you lose your inheritance. Or your mother from property from whom it's coming. But whether you're a convict or not, we don't have politicians don't lose the right. How can anybody lose the right to make a will? Next question.
Where a person is banished by a court from a property owning due to a misbehavior with the parents, and he later influences and occupies the property. Does he have to file the consent terms with the court?
You mean to say that first the parents take the property back,
yeah,
and then they again give it to him?
That is not mentioned. Yeah, he says he later influences them and occupies the property.
Occupies the property is not a part of this will, no?
Yeah. I'm just brushing up.
Let me be very clear. Till a person is alive and it's his personal property, he can do anything with it. He's not answerable for what he does to his property to anybody. So it's up to me if it's my private personal property. Today I give it to my son and ask him to look after me. He doesn't look after me, then under that act, I can take it back. But later on, it doesn't prevent me from making a will in his favor. If there are other beneficiaries, they may use that as a circumstance to say that this is a forged will or a fabricated will. Those are facts which are part of the legal strategies. Yes, next question.
Does the nominee of the bank account have to specifically be named as a beneficiary of that account in the will?
It's up to the person executing the will. If he's not named or somebody else is named, that somebody else will take it. Because you have to understand, a nomination is not attested by a witness. Everybody seems to be misunderstanding that nomination will prevail. A nomination is not attested by two witnesses. Therefore, the nomination in the will, or let's say the beneficiary of the will prevail over the nominee. A nomination is a paper which you make in a bank where you sign and even nobody else signs. Here you have two people looking at you. So this will prevail. Nomination you will get if there's nothing in the will. Therefore, for nominations, etc., normally a person, if he puts it in his will, generally he will go in accordance with the nomination. But if he changes it, he has every right to change it. It is his property, both movable and immovable can be made subject matter of a will. And if there's no will, then it has to go by succession certificate, then it will go to the nominee. Next question.
So for collecting of debts when succession certificate arises, when letter of administration court asks for succession certificate?
If there is no will and the property is generally, say, bank accounts, shares, these sort of movable property, then you have to go for a succession certificate. Because a succession certificate is a summary proceedings. Summary proceedings, you have to understand, is just like a challan. That's the legal value it has. It just gives you a certificate to say that, yes, I have succeeded. But it's not binding on anybody. Next.
If an executor is not appointed in an unregistered will, whether beneficiary should approach court or he can deal with the letter of administration?
I'm sorry, I was reading something else while you were reading.
The last question, if executor is not appointed in an unregistered will, whether beneficiary should approach court or he can deal with the letter of administration?
See, please let me understand. You have a will which is not registered. There is no difference between a registered will and an unregistered will. Both are equally valid. Both have to be executed as per this act and proved as per the Evidence Act. Once it is proved in court, everybody has to obey that certificate. You can obtain a probate even in an unregistered will. I had started by saying this. But if you don't want to obtain a probate, then it will depend on the rules of your organization. Like I told you, I have an example myself, where in Chandigarh, the property was transferred without going to court because all the beneficiaries agreed to the will. In one case, there was no will. All the beneficiaries said, yes, transfer it to person A. And the office, estate office, we have an estate office in Chandigarh, agreed to it. But then the rules regarding transfer of property in municipal records varies from state to state, from society to society, from organization to organization. So please have a look at the rules. And if any of you are in the age of making a will, please have a look at the rules before you make the will. Otherwise, you might, along with the inheritance, you might give your beneficiaries a lot of litigation. So please avoid that. There is one question I wanted to answer. If there's a nominee in a mutual fund, however, he is not mentioned in the will, does he have the right to claim the money under mutual fund? I have answered that. And then there is, what document should a housing society in Mumbai consider if owner has died intestate but made in nomination? If he has died intestate, immovable property goes as per the Succession Act of the individual. The Succession Act is the most important thing. Nominations are there in movable properties. In case it is a certificate, in many housing societies, you have certificates. Then you'll have to go to court. Court will determine to whom is the right coming. Suppose in succession, there are two sons. One is the nominee, and as per the law, both should get it equally. So then the court will determine whether the Succession Act would apply. That's the Hindu Succession Act in case of an Hindu. If it's a Muslim, there are a different act. Everybody's have different act. Or whether the nomination will apply. Normally, the courts tend to lean towards nomination because it's a declaration of a person made during his lifetime. So normally tend to deal towards the nomination. But then the officers will always put you off, tell you to go to court.
Last question is, Gaurav says, please give more details. When you gave example of brother filing a suit against the beneficiary, claiming that the will is legal and valid, but doubting and challenging the share in the bequest.
See, there are a person has 3 sons and 2 daughters. 2 sons go to court or 2 daughters go to court saying, this is my father's will. Now, you know, now even daughters are co-partners now after 2005 amendment. And the father has given the property to the 3 sons. The daughters will come to court and say, yes, we have no issue on the will. But since our father, this was ancestral property, since our father could only will away his share as per the Hindu Succession Act, go back to the end of the provision that he can make a will regarding his share, section 31, I believe, of the Hindu Succession Act. So therefore, the entire disposition regarding the sons is invalid. He can only make a disposition of property regarding his share. Or let's take an extreme example. The property is owned by 2 persons. One person makes a will of the entire property, and you obtain a probate without the other person knowing. Now that person will go to court, obviously, and he'll obtain a declaration, because the court in probate does not decide the legality of the will. It does not even decide whether this property belongs to person A or does not belong to person B. It only gives you a certificate that the will is legal and valid, not its contents. I hope that satisfies.
Last question we will be taking: what is the difference between the succession certificate and heirship certificate?
And
heirship certificate.
See, this heirship certificate is a concept which has come in just lately. It has got no legal basis. There is nothing known as an heirship certificate, but people go and obtain it from the magistrate or from the deputy commissioner. It's only that, yes, I am my father's son. That's all. Or I am my father's daughter. That's about all. It has got no legal value at all. Whereas succession certificate gives the right to deal with that immovable property. It's by a court. That heirship certificate is by an executive authority. They normally ask you when you seek reservation or you seek admission or something of that. So they normally ask you at that time. If you have property which is immovable, it's okay, no problem. You can go and seek a probate or file a suit or whatever you want to, or a partition also. Why I did not use the word partition was because in partition, when the other party, when you will say 2 declarations have to be given in partition. 1, your share, and 2, then that it's a partible estate. So this is it's better to go for a probate, obtain it, and then sit down and try and resolve it with your relatives. The best case is the one which you decide by a compromise.
Nowadays, there's too much importance being given to the ADRs also, only on this account of
yes, I think
mediation.
The best thing to do is to go straight. And nowadays, I think all lawyers are aware that you need not even go to court. You go straight to the permanent lok adalat, and people who are, anybody here who is not from the legal profession, if you have any problem, just take your problem straight to the permanent lok adalat. You need not even come file a suit, file a case before the permanent lok adalat. They'll examine if they're able to do it. They'll pass a decree, call everybody and pass an order. But then that, and the best part is that their orders are final. No appeal against them. I don't want to add anything more to that.
Pre-litigation mediation.
Pre-litigation
mediation is incorporated.
Everything is happening, but I don't know why people, the message is not going. The message is confined to the legal fraternity actually. But it doesn't go out to the general public. The general public doesn't come.
Yes, sir. So we can take one question. That should be the last. How can an administrator distribute the properties amongst the legal heirs? Can it be done through a registered family settlement?
You see, primarily it has to go as per the will of the deceased. if you want to alter the will of the deceased, then there has to be a family settlement. Now, the problem with a family settlement is if the document itself is an inter vivos transfer between the parties of properties, somebody's shareholding increasing, somebody's decreasing, it will be deemed to be a transfer of property, which will be registered. So if such a person would like them to settle it, the best thing to do is to have an oral family settlement, and then after the parties have settled orally, then put that into writing for the purpose of memory. The transfer takes place orally and is therefore not registrable, so you don't pay stamp duty, etc. There are now a large number of Supreme Court judgments starting from 1967, I think, that a oral family settlement need not be registered. Once it is not registered, so no stamp duty on that. So that's the best way to do it. But then sometimes the executive is more wiser. They say, no, you pay it. So people end up paying it. Any other questions, sir?
Sandeep has asked for the email, your email. I will ask you to post it.
I have no issue on anybody sending any amount of mails to me. And on any topic regarding civil law, anything, land laws, anything, you're please welcome. Everybody is welcome to ask any questions. And in fact, I am using this forum actually not for any personal advancement, but my idea is that people who don't know the law should come forward and ask questions. And
share the email, probably that's the correct one.
I don't know, I can't see it.
Rajive Bhalla 1954@gmail.com.
Yeah, please. So please ask any questions.
Thank you, sir. And taking lead from today's session, we'll be taking tomorrow drafting of sale deed, will and process of registration by District Judge S. Nagarajan ML from District Judge Coimbatore. Do stay connected with us tomorrow at 4 p.m. So, and thank you
for
very much sharing your knowledge in a very simplified manner. And remember that the Rubik cube was simplifiedly solved by you. Thank you.
Thank you very much. Thank you.